Hello everyone, my name's Reggie. I'm a registered mental health counselor intern here in the state of Florida, and I'm going to be reading from Section B of the 2014 Code of Ethics. And this video is going to be kind of dry, but this is for educational purposes only. I'm going to be studying for the National Clinical Mental Health Counseling exam, and this is basically just study material for myself and for those who need to learn the Code of Ethics. I did Section A recently in a video, and I'll post that somewhere. And I recently had a client who saw myself and another therapist at the same time, and I was a little confused at what to do because of that, but Section A tells you exactly what to do in that scenario. So I'm a baby therapist, and for us other baby therapists out there, hopefully this will be good study material. So without further ado, I'm going to read from Section B of the 2014 Code of Ethics. Introduction. Counselors recognize that trust is the cornerstone of the counseling relationship. Counselors aspire to earn the trust of clients by creating an ongoing partnership, establishing and upholding appropriate boundaries, and maintaining confidentiality. Counselors communicate the parameters of confidentiality in a culturally competent manner. B.1. Respecting client rights. B.1.A. Multicultural diversity considerations. Counselors maintain awareness and sensitivity regarding cultural meanings of confidentiality and privacy. Counselors respect differing views towards disclosure of information. Counselors hold ongoing discussions with clients as to how, when, and with whom information is to be shared. B.1.B. Respect for privacy. Counselors respect the privacy of prospective and current clients. Counselors request private information from clients only when it is beneficial to the counseling process. B.1.C. Respect for confidentiality. Counselors protect the confidential information of prospective and current clients. Counselors disclose information only with appropriate consent or with sound legal or ethical justification. B.1.D. Explanation of limitations. At initiation and throughout the counseling process, counselors inform clients of the limitations of confidentiality and seek to identify situations in which confidentiality must be breached. B.2. Exceptions. B.2.A. Serious and foreseeable harm and legal requirements. The general requirement that counselors keep information confidential does not apply when disclosure is required to protect clients or identify others from serious and foreseeable harm, or when legal requirements demand that confidential information must be revealed. Counselors consult with other professionals when in doubt as to the validity of an exception. Additional considerations apply when addressing end-of-life issues. B.2.B. Confidentiality regarding end-of-life decisions. Counselors who provide services to terminally ill individuals who are considering hastening their own deaths have the option to maintain confidentiality, depending on applicable laws and the specific circumstances of the situation, and after seeking consultation of supervision from appropriate professional and legal parties. B.2.C. Contagious, life-threatening diseases. When clients disclose that they have a disease commonly known to be communicable and life-threatening, counselors may be justified in disclosing information to identifiable third parties if the parties are known to be at serious and foreseeable risk of contracting the disease. Prior to making a disclosure, counselors assess the intent of clients to inform the third parties about their disease or to engage in any behaviors that may be harmful to an identifiable third party. Counselors adhere to relevant state laws concerning disclosures about disease status. B.2.D. Court-ordered disclosures. When ordered by a court to release confidential or privileged information without a client's permission, counselors seek to obtain written, informed consent from the client or take steps to prohibit the disclosure or have it limited as narrowly as possible because of potential harm to the client or counseling relationship. B.2.E. Minimal disclosure. To the extent possible, clients are informed before confidential information is disclosed and are involved in the disclosure decision-making process. When circumstances require the disclosure of confidential information, only essential information is revealed. B.3. Information shared with others. B.3.A. Subordinates. Counselors make every effort to ensure the privacy and confidentiality of clients are maintained by subordinates including employees, supervisees, students, clerical assistants, and volunteers. B.3.B. Interdisciplinary teams. When services provided to the client involve participation by an interdisciplinary or treatment team, the client will be informed of the team's existence and composition, information being shared, and the purposes of sharing such information. B.3.C. Confidential settings. Counselors discuss confidential information only in settings in which they can reasonably ensure client privacy. B.3.D. Third-party payers. Counselors disclose information to third-party payers only when clients have authorized such disclosure. B.3.E. Transmitting confidential information. Counselors take precautions to ensure the confidentiality of all information transmitted through the use of any medium. B.3.F. Deceased clients. Counselors protect the confidentiality of deceased clients consistent with legal requirements in the documented preferences of the client. B.4. Groups and families. B.4.A. Group work. In group work, counselors clearly explain the importance and parameters of confidentiality for the specific group. B.4.B. Couples and family counseling. In couples and family counseling, counselors clearly define who is considered the client and discuss expectations and limitations of confidentiality. Counselors seek agreement and document in writing such agreement among all involved parties regarding the confidentiality of information. In the absence of an agreement to the contrary, the couple or family is considered to be the client. B.5. Clients lacking capacity to give informed consent. B.5.A. I recently had a client who had dementia and just couldn't do the informed consent. His family had to be there, and that was an interesting scenario. B.5.A. Responsibility to the clients. When counseling minor clients or adult clients who lack the capacity to give voluntary, informed consent, counselors protect the confidentiality of information received in any medium. In the counseling relationship is specified by federal and state laws, written policies, and applicable ethical standards. B.5.B. Responsibility to parents and legal guardians. Counselors inform parents and legal guardians about the role of counselors and the confidential nature of the counseling relationship, consistent with current legal and custodial arrangements. Counselors are sensitive to the cultural diversity of families and respect the inherent rights and responsibilities of parents/guardians regarding the welfare of their children/charges according to the law. Counselors work to establish, as appropriate, collaborative relationships with parents/guardians to best serve clients. B.5.C. Release of confidential information. When counseling minor clients or adults who lack the capacity to give voluntary consent to release confidential information, counselors seek permission from an appropriate third party to disclose information. In such instances, counselors inform clients consistent with their level of understanding and take appropriate measures to safeguard client confidentiality. B.6. Records and documentation. B.6.A. Creating and maintaining records and documentation. Counselors create and maintain records and documentation necessary for rendering professional services. B.6.B. Confidentiality of records and documentation. Counselors ensure that records and documentation kept in any medium are secure and that only authorized persons have access to them. B.6.c. Permission to record. Counselors obtain permission from clients prior to recording sessions through electronic or other means. B.6.d. Permission to observe. Counselors obtain permission from clients prior to allowing any person to observe counseling sessions, review session transcripts, or view recordings of sessions with supervisors, faculty, peers, or others within the training environment. B.6.e. Client access. Counselors provide reasonable access to records and copies of records when requested by competent clients. Counselors limit the access of clients to their records or portions of their records only when there is compelling evidence that such access would cause harm to the client. Counselors document the requests of clients and the rationale for withholding some or all of the records in the files of clients. In situations involving multiple clients, counselors provide individual clients with only those parts of records that relate directly to them and do not include confidential information related to any other client. B.6.f. Assistance with records. When clients request access to their records, counselors provide assistance in consulting and interpreting counseling records. B.6.g. Disclosure or transfer. Unless exceptions to confidentiality exist, counselors obtain written permission from clients to disclose or transfer records to legitimate third parties. Steps are taken to ensure that receivers of counseling records are sensitive to their confidential nature. B.6.h. Storage and disposal after termination. Counselors store records following termination of services to ensure reasonable future access, maintain records in accordance with federal and state laws and statutes such as licensure laws and policies governing records, and dispose of client records and other sensitive material in a manner that protects client confidentiality. Counselors apply careful discretion and deliberation before destroying records that may be needed by a court of law, such as notes on child abuse, suicide, sexual harassment, or violence. B.6.i. Reasonable precautions. Counselors take reasonable precautions to protect client confidentiality in the event of the counselor's termination of practice, incapacity, or death, and appoint a records custodian when identified as appropriate. B.7. Case consultation. And this is the last section. B.7.a. Respect for privacy. Information shared in a consulting relationship is discussed for professional purposes only. Written and oral reports present only data germane to the purposes of the consultation, and every effort is made to protect client identity and to avoid undue invasion of privacy. B.7.b. Disclosure of confidential information. When consulting with colleagues, counselors do not disclose confidential information that reasonably could lead to the identification of a client or other person or organization with whom they have a confidential relationship, unless they have obtained the prior consent of the person or organization, or the disclosure can be avoided. They disclose information only to the extent necessary to achieve the purposes of the consultation. And that concludes Section B of the 2014 ACA Code of Ethics.